Good morning, everybody. My name is Matthew Horn, and I'll be presenting the first presentation of 4 today. Welcome to our 10th annual Construction Industry Legal Power Seminar. It would be difficult for me to imagine a more appropriately timed presentation than the one that you're going to be seeing today. I don't know if we realized at the time that we scheduled it that the election would be a couple days before, and there would be the inauguration would be a couple days before or not. But the inauguration has happened, change is underway, and again, there will be some really good updates and tips in light of this change. We're happy to have you, and we appreciate you help in making this event a success. Before we get started, there are a few housekeeping items to announce. We're taking questions throughout the program, and you can submit them via chat in the window on your screen. We may not be able to get to all of your questions, but we will do our best. We have 4 presentations happening today with a break in the middle. All registrants following the presentation will receive an email after the program, including the video recording and the slides. There will also be an evaluation for your feedback and information about obtaining CLE, SHRM, and HRCI credit. Please keep on the lookout for those. So those are the notes that I was told to read, and so without further ado, we're going to jump into the first presentation. And the first presentation is really a 2-part presentation. So the first half will be about OSHA updates and tips for managing an inspection, and the second part of the first presentation will be about construction contracts and updates in light of the new administration. I've front-loaded the slides for both parts of the presentations to try and hit on the important updates first. And then just given time considerations, assuming we cover those, I will then go into more routine non-updates about how to manage an inspection and how to properly evaluate a construction contract. So here I am. You can see me too, but my name is Matthew Horn, and I am the partner and chair of our construction practice group and our OSHA practice group. And people always ask me how I became the chair of 2 separate groups. Well, the OSHA group was really an offshoot of the construction group. Under the Obama administration, OSHA really exploded. And so I was already sitting very nicely with my construction clients who had OSHA needs. They started asking us to help them with their OSHA needs. And now we have a national OSHA practice group. And we represent not just construction companies, but general industry, healthcare, manufacturing, agriculture, and all phases of OSHA management. So OSHA compliance counseling, OSHA inspection management, evaluating and settling OSHA citations, litigating citations. We probably litigate more OSHA citations than anybody in the country, assisting with crisis management, resolving union and employee complaints, and defending whistleblower claims. So the updates, why you're really here, right? Why you're here at 8 a.m. on a Thursday, a beautiful Thursday. You want to know what's happening, right, for 2025 and beyond. So the current state of OSHA, and there's an asterisk next to this, right, because we're expecting significant changes across all elements of the federal government. But what are we seeing right now? What am I dealing with on a day-to-day basis right now? I'm dealing with more regulation, more inspections, and more citations. The other thing that we're dealing with is there are a lot of new inspectors out there. There's a lot of rookies. It got a lot of press a couple years ago under the Biden administration, them hiring all these new IRS agents. What got less press but was also important was the hiring of all these new OSHA inspectors. And so the new inspectors are the most dangerous ones because they love their power and they don't really know what to do, so you have to control them. OSHA is always trying to expand inspections now, right? So it used to just be you had an accident, and they came out, and they just looked into the accident, and maybe you got a citation or 2. Now they come out, they look at the accident, they look around the facility or the job site, and they say, oh, we're going to expand this inspection under a national emphasis program or a local emphasis program, and now all of a sudden you've got 10 citations. We're dealing with increased fines and repeat and willful citations. Many 6-figure citation packets are going out. And so I think this is one of the things that's going to stop pretty quickly here. But for the past 4 years, we've been dealing with willful citations frequently, very frequently. More press releases, placements into the severe violators program. This is something that really took off in the last 4 years. But again, this is all likely to change very, very soon. The Department of Labor leadership, and why is it going to change? Well, for the past 2 years, the acting Secretary of Labor, Julie Su, who was never confirmed but ran the department for 2 years, is out. And so this kind of gave us an insight as to what happens when your nominee is not confirmed. And Julie Su was never confirmed, but she ran the department for 2 years anyways. So this is something that we could be seeing in the administration, the current administration moving forward. The reality being, even if a nominee is not confirmed, it appears that you can just make them the acting secretary of something. Who is Trump's current nominee? It's Lori Chavez de Ramir. She's a one-term Republican representative from Oregon. Unlike her predecessor, she is expected to get confirmed with support from Republicans and labor unions alike. I don't know much about her, but everything I read says that the labor unions support her, the Republicans support her, so I'm fully expecting that she is going to be confirmed. She's likely to oversee a quieter, more moderate Department of Labor and OSHA, unlike her predecessor, right? So one of the things that this administration has run on is less regulation, less regulation, less regulation. So I think we're going to go back to what we saw under the initial Trump administration with OSHA, which is it's not a complete dialing back or rolling back of OSHA, but it's certainly a less aggressive OSHA, and it's certainly an OSHA that's not issuing repeat and willful citations with the same frequency that have been issued in the last 4 years. Well, now, what could change this? DOGE, right? The Department of Government Efficiency, run by Elon Musk, could change everything, and they have even hinted at and mentioned doing away with OSHA entirely. Do I think that will happen? No. Is anything possible? Yes. The new online reporting rule. So this is a rule that was initially attempted to be implemented by the Obama administration, and it was resurrected under the Biden administration, and it's at least currently the law of the land. So it applies to employers with 100 or more employees in high hazard industries such as construction. And it requires those employers to submit information from their 300 logs and 301 reports, in addition to the 300A information already required, right? So for the last, and I lose track of time, let's just say the last 5 years, most employers have been required to submit their 300A data online each year. This rule will require employers with 100 or more employees to submit not just the 300A summary data, but the 300 logs and the information from the 301 reports themselves. What is OSHA doing with this data? Well, at first they weren't doing anything with it, but now they are publicly disclosing it. And oddly enough, they publicly disclose it by way of an Excel spreadsheet. So if you go to their website and you click on the data, and they release the data every year by way of a press release, and you click on the data, it pops up an Excel spreadsheet, which can be searched by employer, by injury, by NAICS code, by all of these things. So just know that once you report your data to OSHA, it is out there. It is in the public domain. OSHA's national emphasis programs. So these are currently what OSHA is focusing on. And the current national emphasis programs are hazardous machinery, primarily machinery that can cause amputations. Heat, this is a huge one that I'm going to talk a little bit more about later. Hex, chrome, lead, silica, combustible dust. Trenching and excavating, a big one for construction. Primary metal industries, fall protection, again, another big one for construction. And then warehousing and processing. OSHA can conduct a planned inspection into these NEPs at any time, and they're now using them to expand inspections also. Now the NEPs, up until 4 or 5 years ago, I had never dealt with a planned national emphasis program inspection, and now I'm dealing with them on a weekly basis. Do I expect that that level of activity on the national emphasis programs will continue moving forward? No, I don't. But it is possible. It is something that OSHA's shiny new object, if you will. So what do? They show up at your facility. They say, we're here for a national emphasis program inspection. They say, you randomly came up on a list under the national emphasis program, and pursuant to that randomized list, we are here to inspect you. What makes it crazy is you say, okay, provide me with some support, some justification that I came up on this randomized list, and then they refuse. So you have to be prepared to intelligently push back if somebody comes out on a national emphasis inspection, and ensure that you were appropriately identified under the national emphasis program. And more often than not, I find that once you push back and you make them establish that you were properly identified, they can't. So be prepared to deal with that. OSHA is focusing on employers with temporary employees. This has been a long-time policy. OSHA's local emphasis programs in Region 5, which is essentially the Midwest region. Building renovation, rehabilitation, demolition, high-rise building construction in Chicago. There's been a lot of high-rise inspections lately. Wood pallet manufacturing, noise. Noise is a big one. Food manufacturing industries, grain handling facilities, powered industrial trucks, forklifts, always a big one, and then transportation tank cleaning operations. Same things apply as to local emphasis programs as national emphasis programs. OSHA is using them to conduct inspections of employers who otherwise wouldn't be subject to an inspection. They're also using it to expand inspections when they come out for an injury or complaint inspection. Common citations. So, these really don't change that much over time, but these are the ones that you have to be aware of, and these are the ones that OSHA is focusing on, and when they come out to your job site, this is what they're going to be looking at. Fall protection and guardrails, ladders, training requirements. Training has become a big one, right? OSHA is really focused on, they want to see documented training for every hazard encountered by an employee on a project. I think the easiest way to comply with training requirements is to have a safety orientation for all new employees and then have an annual comprehensive retraining, right? That way you are compliant and ensure that you are compliant for all of your employees. Eye and face protection. Head protection is a new one. Head protection is something that's changing over time, right? OSHA is now kind of looking for the helmets. They want people using the helmets with chin straps. They haven't made it a standard yet, but that's where they're going. Scaffolds, fall protection and access, aerial lifts, respiratory protection, HAZCOM, powered industrial trucks, always a big one, and then machine guarding. Very similar for general industry, and I won't go through them, but some additional ones are the PPE hazard assessment, exit routes, fire extinguishers. All right. OSHA's national emphasis program on heat. So there's been a lot of activity on this in the last 6 or so months. And so as we all know, heat is a legitimate safety concern. I have had many heat stroke cases, especially on construction projects. But as we also know, climate and heat is also very political at this point. So these are snips from the National Emphasis Program themselves, talking about tackling the climate crisis at home and abroad and things like that. So with the current National Emphasis Program on heat, what we're seeing in the Chicagoland area and everywhere else is when it gets hot, look out, right? So I can speak from experience that when it is over 90 degrees in a particular geographic area, OSHA essentially refocuses its efforts and its inspectors from whatever they're doing to heat inspections. So they drive around, they look for predominantly construction projects, and they open inspections under the heat national emphasis programs. Inspections target the plain view inspection. And so this lists really who they're looking into, but construction is the lowest hanging fruit in terms of heat. Because they don't need permission or a warrant to get in, right? They can look at your job site, usually from a public right-of-way, and determine whether people are working and determine whether the appropriate heat-related protections have been adopted. Inspections under the NEP. So they happen when it's hot outside, and they drive around, and they open these heat inspections. And what do they usually do? They ask to see water in shaded areas. They talk to the employees, asking them about heat and the protective measures. They then request information and documentation. And if OSHA has if the employer has everything that OSHA suggests, they usually close the inspection. If they don't have everything that OSHA suggests, then general duty clause citations typically follow. What are your heat-related responsibilities? Create a heat illness prevention plan, train employees on heat and the plan, maintain documentation for that training, provide heat acclimation for new employees, provide water, shade, and access to AC for all employees, allow employees to take breaks as needed, ensure employees watch out for one another, post OSHA's posters on heat. If you do this, you will be just fine. OSHA actually has a great tool, great online. I like OSHA's website in general, but they have a really good tool for employers' heat-related responsibilities where you can basically print and download everything that you're required to have. Heat citations and defending citations. So I talked a little bit about the heat requirements, but the reality is there is no OSHA standard relating to heat. And that's why when OSHA issues citations under heat, they have to do it pursuant to the general duty clause. For the most part, it's fairly easy to defend these citations if you have practically or reasonably complied with OSHA's recommendation. The heat did not rise to the level of being hazardous, or there's no prolonged exposure or strenuous activity in the heat. When does OSHA come out and conduct these NEPs and what is hazardous heat? They largely rely on this table. And in order for them to come out and do inspections and issue citations, generally you have to be in the danger or extreme danger temperatures. Now, you're saying, Matt, it's pretty self-explanatory stuff. Give them water, give them shade. Why are you telling me this? I'm telling you this because OSHA has a proposed rule on heat that is pending. And so after years of trying, they finally introduced the rule and standard aimed at mitigating heat-related risks in the workplace. What is the status of that? So they issued the proposed rule. It's out there. You can search it and find it if you want. There was a formal commenting period on it that ended on January 14th, 2025. And the next deadline is an informal public hearing scheduled for June 16th, 2025. What do I think is going to happen with the rule? I think it's likely to disappear or change significantly, but you never know, right? And we talked about the incoming Secretary of Labor being friendly to the labor unions, and the labor unions like the rule. The labor unions want the rule. So it could be here to stay. Let me tell you a little bit about the rule. So pursuant to the rule, which is pending, employers in all industries are required to develop injury and illness prevention plans for heat hazards, which must include risk evaluations, water and rest breaks, indoor heat control, worker acclimatization, training, and emergency response. Now, what's important in the rule? What do you really need to know? So in the proposed rule, there are two thresholds for a heat index. There is what's referred to as an initial heat trigger that is 80 degrees, and then there's a high heat trigger that is 90 degrees. So you have to have a program, do training, and provide water at the initial heat trigger temperature, right? 80 degrees. So at some point, virtually any employer is going to encounter 80 degrees. So you would need to comply with the initial heat trigger requirements off the bat. When does it get crazy? It gets crazy at 90 degrees. So 90 degrees or warmer, the employer must provide employees a minimum of 15-minute paid rest break at least every 2 hours in a cool, shaded, or air-conditioned area. So in short, in an 8-hour day, 1 hour must be spent resting in a cooled area. All right. This is very significant for construction projects in the summer, construction projects in the south, where it's typically above 90 degrees, and then general industry, especially in the south and in the summer. Again, even if the rule is adopted, it is likely to change. There has been significant pushback as to the 90-degree requirements, most notably providing employees with a 15-minute paid rest break in a cool or shaded area at least every 2 hours. But know that that's on the radar, all right? Now, I'm going to quickly, I've only got a couple minutes left for this OSHA inspection, or the OSHA presentation, but I am going to go through some tips for managing an OSHA inspection, right? And again, I think we're going to see a dialed back OSHA moving forward, but you know, it's not going to be like it was under the Bush administrations or previous. There are going to be a lot of inspections and there are going to be a lot of citations, albeit less willful citations than we've seen. So what does OSHA want to see, right? They want to see safety programs, safety training, monitoring of employees to ensure that they're following the training, and then disciplining employees when they don't, and documenting all of that. That's what OSHA wants to see. And if you do that, in OSHA's eyes, you have a really good safety program. And if you have a really good safety program, then you've entitled yourself to what's called the employee misconduct offense. And the employee misconduct offense is essentially a get-out-of-jail-free card for OSHA citations and in the OSHA context. So, you know, if you do these things, have a program, train on it, do inspections, discipline employees when they don't follow it, and document it, you've essentially got yourself an OSHA get-out-of-jail-free card. I have seen it work in the past for many of my clients who have really good safety programs where OSHA will conduct an inspection and they won't issue citations. Or if they issue citations, they'll agree to vacate the citations at the informal conference stage because the employer has such a good safety program. Common citations, so we've got the serious, the willful, the repeat, the failure to abate, the other than serious. At this juncture, fines are increasing annually with inflation. They just went up, and these are the current fines: $16,550 for a serious, $165,514 for a willful, a repeat, etc. So these are going up every year at this point. Contacting OSHA. So while we're talking about updates, we should also talk about the newish reporting rule for OSHA, because I would say every month I get a new client who calls me that isn't aware of the rule. So, and the new rule was probably enacted, I lose track of time, but I would say 10, maybe even 15 years ago. Many people still don't know about it though. So what are the reporting requirements if you have an injury? You have to report a fatality that occurs within 30 days of a work-related accident. So you've always had to report fatalities. Even under the old rule, you had to report fatalities, and you still have to report fatalities now. You're supposed to report them within 8 hours of the fatality. This is the important change. You must also report any incident resulting in an amputation, even the end of a finger, loss of an eye, or the hospitalization of an employee within 24 hours of the incident, all right? Hospitalization means admitted inpatient for medical treatment, all right? There's a lot of confusion about the definition of and requirement for reporting hospitalizations, but the employee has to be admitted inpatient for medical treatment. That means if they're treated in the ER and released, you don't have to report it. If they're treated in the ER, admitted inpatient for diagnostic testing or observation, and then released, you don't have to report it. So just make sure that you're only reporting things that need to be reported and you're not reporting things that don't. Because if you report something erroneously that you didn't need to report, and then you realize, oh, I didn't need to report this, there is no clawing that back, right? Once the toothpaste is out of the tube, it's out of the tube, it's not going back in. Same thing with reporting an incident. Also know that the inpatient hospitalization has to occur within 24 hours of the incident, right? So if an employee throws their back out lifting something heavy and they don't go to the hospital for 2 days and they aren't admitted inpatient for 2.5 days, you don't have to report that. Why is this important? It's resulting in more inspections than ever, right? The inspection process, so this is generally how an inspection flows. Again, I kind of front-loaded the slides to talk about the updates, so I'm going to fly through these, and then we'll get on to the construction contracts. Again, this presentation will be sent to you, and if you would like to know how to manage an inspection, or you're undergoing an inspection now, please rely on this slideshow. It will help you. The opening conference, so is when the inspector comes. Consent in the OSHA inspection, very important. Just understand that all OSHA activities are voluntary. Unless they have a warrant, all activities are voluntary, meaning you control the inspection, not them. They don't want you to know that. The walk around, they walk around the project. You always want to try and focus on the underlying purpose for the inspection. If there was a complaint or an injury, focusing them there and there alone. Don't allow them to walk around. Employee interviews. Make sure employees know their rights going into interviews. Make sure that they are comfortable. They have rights. Again, entirely voluntary. Document requests. Again, make sure that these are appropriate in light of the appropriate scope of the inspection. Don't provide them with documents that are outside the scope. Don't provide them with documents that they haven't requested. Sorry, I'm catching up here. All right. Closing conference. OSHA has 6 months to close an OSHA inspection. They'll usually take 3 to 4 of those months. The closing conference is when OSHA tells you what citations they're going to be issuing, largely a listening exercise. The issuance of citations, I would say 95% of inspections that are initiated result in citations at this point. So if you're the subject of an inspection, especially if they make a document request, you're likely going to be issued citations. Make sure that you handle them quickly and appropriately. How to respond, you have a number of options. I always suggest going to the informal conference with the area director, trying to make a connection, tell them about your safety program, try and negotiate an appropriate resolution on the merits, When we talk about the merits, you have to understand whether the citation you've been issued are appropriate or not. If it's not appropriate, you have to tell OSHA they have to vacate it, right? You have to be informed. You have to go to the conference with the area director and make informed arguments and try and reach a resolution on the merits. These are the typical defenses. There are many defenses. So in my experience, at least half of the OSHA citations issued are invalid. At least half, probably more like 75%. Settlement techniques. So just know that you can do anything you want to settle it. You can change classifications. You can offer additional abatement. You can group citations. You can do all of these things. To contest or not to contest. At this juncture, I recommend contesting probably about 60 or 70% of the time. If OSHA will make a good offer on the merits at the informal conference, great, you should accept it. If not, you should contest it. The contest process, once you contest, most cases settle. OSHA's offer, I have never seen get worse. It almost always gets better. And if you can't settle it, it usually proceeds to small-scale litigation with a resolution in 12 to 15 months. One thing to point out is the OSHA appellate court is supposed to consist of 3 commissioners, and right now it consists of 1, and it has consisted of 1 for a number of years. And so the OSHA appellate body has not been issuing decisions for the better part of 3 to 4 years. So just know that if you ever get stuck in the OSHA appellate process, it's not moving at all right now, although I do anticipate that that will change here at some point in the future.
So we have 2 questions from the chat.
Okay.
The first one is, if an employer with 100 plus employees in designated high hazard industry uses Illinois Form 45, will they have to duplicate efforts to fill out 301s and report online?
No, so Illinois Form 45s are an acceptable substitute for the 301. I have never entered the data for a 301 online personally myself, but my expectation is that it's the same information from the Illinois Form 45, and OSHA will accept an Illinois Form 45 in lieu of an OSHA 301.
And the next question here is, in terms of heat, can the cooled area for a company truck be a company truck or an employee car?
Yes, it can. It has to have air conditioning. So I used to work in construction. Back then, and that was a long time ago, most of our trucks didn't have air conditioning, but if they have air conditioning in the company vehicle or their own vehicle, yes, that should suffice. Okay, all right. So now we're moving on to construction contracts. So I'm Matt Horn. I'm the construction chair too. So let's talk about construction contracts, provisions impacting the bottom line and updates for 2025. Again, this is a very appropriately timed presentation. So the topics that I'm going to cover, and again, just like the last one, I'm going to front load what I think are the important updates, and then I'll talk about the typical process and what I look for when I am reviewing and revising and negotiating a contract. But the current issues, right? So we're talking about trade wars. We're talking about tariffs. We're talking about trade wars. I fully expect there's going to be significant tariff activity. I fully expect there's going to be some form of trade wars. And so what are we going to see with that, right? Well, I think we saw it under the previous administration. Granted, COVID had kind of added an interesting element to that. But I think we're going to see a lot of the same things, right? I think we're going to see supply chain issues and delays. We're going to see material shortages, material escalation, obviously tariffs, which is going to drive all of it. We're going to see labor escalation, especially with the ongoing deportation effort. And then just at the end, we should talk about the Illinois wage payment and collection law. Assuming we get through that in terms of time, these are the contractual provisions that I pay close attention to when I am reviewing, revising, and negotiating a contract, and we can talk about that as time permits. Contract issues and disputes, right? So for a long time, the construction industry was governed by relationships, right? A lot of times people didn't even have contracts 10 years ago, 15 years ago, certainly 20 years ago. But it's changing, right? It's changing. And it's being forced to change by attorneys, by the courts. There's a lot going on in terms of the next generation. Many construction companies are family owned, and you've got the next generation coming in. You've got private equity buying construction companies. And so they're all becoming less relationship based, more contract based, more paper based. And so, although overall in the construction industry, I'd say disputes only arise in limited circumstances because everybody's fairly practical and relationship-based, it is becoming more frequent, right? And so what is the number one driver of disputes in construction? Well, they usually arise because both parties have a different understanding of the contract terms, or the terms do not comply with custom and practice, right? So parties will get into dispute without even really looking at the contract. Parties will get in dispute because the terms of the contract that they sign differ from what they usually do, different for custom and practice. The goal is not to win a contract dispute, but avoid them altogether. When should you be on high alert? When contracting with a new entity, an entity that is known to be difficult. There's a number of those in the Chicagoland market, certainly, and an entity that will not negotiate its contract. That's the biggest red flag for me. If somebody says, here's our contract, we're not going to negotiate it, then you need to really scrutinize it. Current issues. So, supply chain issues and delays. Lack of freight capacity, disruption of raw materials, materials stuck in port. Again, I think we're going to see a lot of this with what's going to happen with the tariffs. And, at this juncture, we're talking about tariffs on China, Canada, Mexico, Secretary of State Marco Rubio is headed to Panama to discuss the Panama Canal. We're in active negotiations, I think, with Denmark over Greenland. So what is this going to result in? It's going to result in just a disruption of everything, at least in the short term. We're going to see material shortages, especially things being imported into the country, associated escalation in tariffs, right? What did we see last time? So electrical components, there is still a significant delay to get switchgear and electrical components and all of those things. But what have we seen in the past and what do I expect? Steel, concrete, insulation, lumber, pipe, roofing materials, all of those things. I think there are going to be issues. Labor strikes, shortages, and escalation. So again, the reality is with the ongoing deportation effort, and if it continues as it's been promised, I think we're going to see fewer workers. We've also got the construction workforce is old and largely retiring and not being replaced, giving unions more power, right? But the unions are trying to find people too. They can't even find people. So what are we going to see? Higher wages, more strikes, less workers, all of it. The evolution of the industry. So I will say, for up until COVID, the construction industry was pretty level, pretty even keel. And then things started to change. And things have just continued to change, and the industry has evolved since COVID in light of the issues that we've discussed. But what are we going to see? I think we're going to see suppliers consistently changing their prices like we did post-COVID, especially with the tariffs coming. I've already seen suppliers issuing notices telling their customers to anticipate rising prices because of expected tariffs. What else are we seeing? Owners willing to accept delays, material escalation, labor escalation. So up until COVID, I mean, you weren't negotiating any of these provisions. Nobody was accepting compensable delays, material escalation, labor escalation. But now it's become the norm to some extent. General contractors are pushing to recover delay and escalation costs. So are subcontractors. Subcontractors and specialty contractors, especially those that are involved in manufacturing, so precast panels, manholes, electrical components. These specialty contractors have more power than ever. And they're refusing to accept no damage for delay and no escalation clauses. What else are we seeing? What else do I expect to see? Bid and contract prices changing prior to the initiation of work, right? So if you bid a project and tariffs come down a week from now and the work isn't supposed to start for 6 months, what are you going to do, right? You're going to have to change your pricing. Now, what contract provisions, so right, construction contracts, sometimes can be 100+ page affairs, right? What should you be focusing on in light of these issues? You should be looking at the applicable laws section, the date of commencement section. So the date of commencement has become more important than ever. When are we going to start? Am I going to be allowed to adjust my prices prior to that start date? We're looking at delays in force majeure provisions, suspension provisions. If you can't get the material, right? Some electrical switchgear is taking 12 to 18 months. Claims for additional time and compensation. So contractors want additional time and compensation for delays and increased costs, but if they're not permitted upstream, then it needs to be negotiated appropriately downstream. Examples: materials not available, the materials delayed, material escalation, tariffs, insufficient workforce, strikes, owner stoppages, no inspections, increased general conditions. So what should you do? Well, you should negotiate contracts moving forward based on your past experience. And I think even though thankfully there's no COVID this time around, I think the experience post-COVID in light of the tariffs and things will provide you some insight as to what to expect moving forward. AIA and other forms don't account for today's construction world. They just don't. So you have to revise them accordingly. And I say go beyond the generic and be specific, right? Talk specifically in specific terms about labor escalation. I'm sorry, material escalation and labor escalation. So if the cost of material increases over 2% or 5% or 10%, you're entitled to a change order for that increased cost. So talk specifically about what you're anticipating. Address it specifically. Why? Because then there's no misconception on the other side. If you're trying to rely on the vague general wording of an AIA provision that doesn't talk specifically about material escalation, that doesn't talk about tariffs, that doesn't talk about delays relating to trade wars and tariffs and policy, then you should include that. Again, and this is just an example. Many of my clients, we are preparing material escalation provisions to insert in their contracts and have been for the last couple months. So prepare those provisions now, have them ready to go, so when you're getting contracts, you can just insert them. Delay and escalation claims. So, assuming you're experiencing a delay, assuming you're experiencing an escalation, then you need to review contracts for deadlines, the notice required, and whether you're entitled to an extension of time or additional compensation or both. Make sure you timely assert your claims, right? Most contractual provisions require you to assert your claim within, it can be anywhere from 2 to 7 business days. Failure to timely or properly assert a delay claim often results in it being waived. Support your claim with proof. Again, go beyond the generic and be specific. Provide them with a critical path, invoices from the supplier, emails from the supplier, photographs, supplier notifications, etc. Most of these claims can still be tied back to COVID, right? Including still the electrical delays, which can be tied to force majeure, but now they're also likely tied to tariff and trade policies too moving forward. And again, just make sure that you're drafting and revising your contracts appropriately. Be prepared to support your claim, right? Nobody wants to accept these claims. Nobody wants unexpected costs. Nobody wants unexpected increased costs. So you have to beat them over the head with the support. You have to point out the specific contractual provision entitling you to labor escalation. You have to attach the invoice or the email from the supplier saying, as a result of the tariffs, our costs have increased 15%. Be prepared to fight your claim and be prepared to negotiate your claim. Here is an example of a notice of delay and potential increased cost notice. And so, you can use this as a form, assuming you don't have your own form. It doesn't need to be fancy. It should reference the specific contractual provisions implicated and should explain in plain language the delay and attach any support. Again, this is a type of notice that one of my clients received from a supplier, basically saying, hey, we have supply chain challenges. We have increased costs. Here's why. Strong demand with reduced global supply chain disruptions, limited freight availability. So attach these things. Generally, in the past, most construction contracts included a no damage for delay provision, right? If there was a delay, you were potentially entitled to an extension of time, but you weren't entitled to additional costs. For the most part, those provisions are legally binding and upheld, right? So if you just sign an old, a construction form that was prepared 10 years ago, it will typically say there is no damage for delay and you are not entitled to any increased costs, right? And so if you don't negotiate that and you accept that older form, those are binding. Those are binding and upheld. There's one exception. So the exception is the delays and costs are not contemplated by the parties at the time of the contract, right? I think there was a good excuse for that, for COVID, which people really didn't anticipate. But I think if you try and make that argument as to tariffs now, what the other side's going to say is, well, this administration has been threatening tariffs for the entire campaign. What is that, better part of a year? But just know that generally those provisions are upheld. There is an exception if something is just totally not contemplated by the parties. Price escalation before the work. I think this is going to be a really big one, right? What's the major issue? Price escalation is occurring after bids are submitted or a contract has been executed, but before the work is started, right? So if you bid a project yesterday and you're getting lumber from Canada, and now that lumber is going to be subject to a 10 or 20 or 25% tariff, that's going to change your pricing, right? If the project doesn't start for 3 or 4 months, well, now you're in the hole unless you can change your pricing. So condition your bids and contracts on price escalation prior to the initiation of work, right? We're not going to know. We're not going to be able to say, oh, the tariff's going to be 10% 6 months from now. We don't know. Especially if there's no firm date for the start of work, right? If you sign, and a lot of times people are signing contracts and it's just, well, the owner will issue an authorize or a notice to proceed. And then the notice to proceed doesn't come for a year or 2 years. Well, now you need to change all your pricing. Alternatively, set the pricing time limit, right? This proposal, this bid remains good for 30 days. Illinois wage payment and collection law, I touched upon this, I think it was last year, but just know that this law exists now and unions are pursuing it aggressively to recover unpaid union dues and wages. And so what it essentially provides is that upstream contractors are liable for downstream contractors' unpaid wages and benefits. There are exemptions, which are union contractors on public projects work on single-family homes, but essentially non-union general contractors are now liable for union subcontractors' unpaid union obligations. Unions are pursuing general contractors and other upstream entities and owners and developers under this law routinely. So what should you do? Require subcontractors to post the appropriate bonds, require subcontractors to provide routine confirmation from unions that an obligation has been satisfied, make principals of subcontractors personally liable for any liability under the law. All right, I am out of time. These are the important contract clauses that I typically review closely, revise and negotiate. So we'll just run through it in 2 minutes. We've got the incorporation clause, which incorporates all types of other documents, usually the upstream contracts, into your contract. So your contract usually is not just your contract, but the other things incorporated. Conflict clauses that set out what happens in the event that these various documents conflict. Pay if and when paid. This is a big one. Just know that pay if and when paid clauses are valid, but they only apply and they're only valid when they're properly drafted. And so make sure that yours, if you're adopting it, is properly and specifically drafted, because if not, it will not be upheld. Retention, just know that the retention law in Illinois changed. It basically says 10% is the max, and there needs to be a mandatory decrease to 5% upon 50% completion, but most owners are just ignoring that or contracting it away. Changes and extras in writing, always the biggest driver of construction disputes, so make sure that you look at it very closely and adhere to it and the requirements. Discretionary language has no place in construction contracts. Remove all discretionary language. Upstream discretionary language, if you can get downstream discretionary language, great. Defense and indemnity clauses, know that defense and indemnity are two separate things. Indemnity basically means that they'll pay a judgment or a claim on your behalf. Defense means they'll pay for your attorneys. Which one's more costly? Which one's more important? Usually the defense. Additional insured, this has been around for a while. If you're required to name somebody as an additional insured, ensure that you do. And then mediation versus arbitration versus litigation. Everybody asks me about this, which one do you prefer? It depends on your goals. Arbitration is quicker, but you can get a ruling that does not conform with the law. So a lot of times what the arbitrator does is they split the baby. Litigation is slower. If you want to drag the costs out over many years, litigation is the way to go. And usually you will get at least a reasoned decision. Attorney's fee provisions, include them. Make sure that they are mutual. And that is it. Any questions? No questions. So, thank you again for joining me this morning. I appreciate it. I hope that it was helpful. You will get the presentation and the slides in an email after the presentation, but if anybody has any questions or comments about OSHA or construction contracts, there is my contact information. Email, call me. I'm around whenever. My wife's not thrilled about that, but I pick up the phone almost any time. And so we're going to take a brief break here, and then we have another wonderful presentation on government regulations and legal mandates. Thank you very much.